Our moderator first, Jay Lefkowitz, who's a partner with Kirkland and Ellis and is a member of the Global Executive Management Committee. He is a member of the Foundation's Legal Policy Advisory Board. He successfully argued two of the seminal preemption cases that will be discussed today, Cleaver versus Metzing, Mutual Pharmaceutical versus Bartlett. Prior to joining the firm, Mr. Lefkowitz served as President George H.W. Bush's Director of Cabinet Affairs and President George W. Bush's General Counsel of the Office of Management and Budget, and also as Deputy Director of Domestic Policy. Jay, over to you.
Thank you, Glenn. Good morning, everyone. I'm really pleased to be on a program with such an illustrious group of lawyers who really know this issue inside and out. I'll introduce the three panelists, make a few introductory remarks very briefly about where we are in the field of preemption in the drug and device industry, and then we'll ask each of the three speakers to talk briefly, and I might, before we move from speaker to speaker, follow up with a question or two for you. I think we're going to start with Jeff Bucholtz. Jeff is a partner in the Washington office of King and Spalding. Previously, he served in a number of positions in the Justice Department, and in fact, on one occasion when some public interest group was trying to subpoena me after I was out of government, Jeff actually served as my lawyer and successfully kept the case out of the Eastern District of New York, which would have been bad news, and got it back into D.C., and the case moved along without my testimony, so thank you, Jeff. Willie J. is a partner with the Goodwin and Proctor law firm. I've worked very closely with Willie over the years on a number of cases, preemption and otherwise, and was worked a little bit with Willie this past year when he successfully argued a case at the Supreme Court involving patent law. Willie is formerly a Assistant Solicitor General of the United States and is really an accomplished appellate lawyer. And Andrew Tauber, it's really a pleasure for me to be on the panel with Andrew because Andy's the only one here I don't know that well, and it's really a thrill for me. Over the last couple of years, I've gotten more involved in a lot of device preemption litigation, having first come to this through the drug world. And everywhere I have traveled in the device world, I've seen Andy's footprints and read his seminal article on how to argue a device preemption case. So it's really a pleasure to have such an illustrious panel today. There's a lot that's gone on in the area of preemption, and it really, I guess it started really back, in a sense, during the Bush administration when the administration took a decidedly pro-preemption approach, started filing amicus briefs in a variety of cases around the country, went out with a proposed new regulation on labeling, and all of this crystallized in the Wyeth case, which was the lead brand preemption case, which was very hotly anticipated. A lot of people thought that might be the moment for preemption in the brand industry. The court rejected preemption somewhat narrowly, though, at least that's the expressed interpretation, and finding that when there is clear evidence that the FDA would not permit a brand to make a label change, well, then there would be preemption. But in all other respects, because the brand companies have the ability to change the labels through the CBE process, there is no preemption. On the heels of Wyeth, courts all around the country basically applied that no preemption policy for brands as well as generic companies. And after a couple of years of having pretty much every appellate decision in the country go anti-preemption for generics, the generic industry moved in with the Mensing case, and the court, in a 5-4 decision, supported preemption on impossibility grounds. The first effort to do an end run around that was the Bartlett case out of the First Circuit, where the First Circuit adopted the stop selling theory, and the court rejected that roundly in the Bartlett decision. Since the Bartlett decision, there have been a variety of efforts to try to peel back generic preemption. We'll talk a little bit about that. The failure to update the label is right now the most interesting and most vulnerable part of generic preemption, although it doesn't apply to that many companies and to that many drugs. But there is a circuit split there, and there's some interesting cases, although the court has thus far not been interested in taking the case. On the brand side, there are a couple of very interesting issues. Most interesting are some cases that are now potentially being ready for review by the court, involving what the appropriate standard for clear evidence would be. What is it that one would have to show to demonstrate that the FDA would in fact have rejected the proposed label change? And there's one case that's going to be at the court for cert petition just in a few weeks. And then, of course, in the device preemption arena, I think a lot of people expected that the court would take the Stengel case. There's a clear split. Even the Solicitor General acknowledged that the courts around the country are really all over the place. And so it's kind of a mystery. Maybe the court has just got preemption fatigue right now, but there certainly are areas both in the drug and the device arena right now that are ripe for review by the court. So with that, why don't we turn it over to Jeff to begin, and we'll have some opportunities for some dialogue with the panel and some questions afterwards.
Thanks, Jay. Excuse me. Thanks, everybody. So I'm going to focus on two recent cases that illustrate the two ways that brand companies have been able or are trying to get out from under the adverse result in Wyeth. One Jay alluded to, and that's this clear evidence exception. Wyeth, in rejecting preemption on the facts of that case, contained a little bit of a caveat that said maybe it'd be different if there were clear evidence that FDA would have rejected the label change that the plaintiff says state law required the company to make. That was not developed in Wyeth. It was somewhat cryptic, and the overall tone of the opinion was so hostile to preemption, and I think, hopes, as Jay said, had been very high in the industry for a different result in Wyeth. And so in the immediate aftermath of Wyeth, it did not seem like that was going to be, and lower courts were not interpreting that as a very broad exception. But companies have been litigating that and have won some cases, and as Jay alluded to, there's a case that I'm going to focus on called Rekith from the Massachusetts Supreme Judicial Court that illustrates, I think, the problems with how the lower courts have interpreted that exception in a very narrow way. But the second path to finding preemption despite Wyeth that I want to mention is illustrated by a recent First Circuit decision, somewhat better, Jay, than the Bartlett First Circuit decision for those of us on this side, and that's the Lexapro case from earlier in 2015, where I think for the first time an appellate decision put Wyeth together with Mensing, which refined the analysis significantly in a much more favorable way to preemption, and laid out what the standard, what the analysis should be now. And so you look at Wyeth itself, and although the court did rely on the availability of FDA's changes being affected, or CBE regulation, which would allow the brand company to make a unilateral label change along the lines of what state law supposedly required without having to get FDA approval. The court did rely on that, but the court also relied heavily on a presumption against preemption. It relied on the perception that Congress intended compensatory state law remedies to remain available, given the absence of any federal law compensatory remedy. It relied on a generalized notion that Congress viewed state tort law as complementary of FDA regulation and not in conflict. And it even managed to drop a footnote noting that there had been some disagreement within FDA about the pro-preemption stance that Jay alluded to. Not that that really should be relevant to the legal analysis. In any event, the opinion was so hostile to preemption and relied on so many different factors together that it was unclear really what the dispositive factor was. Mensing changed that. Mensing said the difference between the reason why there was preemption for the generic company in Mensing and why there had not been in Wyeth was very simple, the availability of the CBE regulation. And it's not that the court likes generic companies better than brand companies, it's that generic companies do not have available to them the CBE regulation, period, and therefore could not make a unilateral label change to do what state law supposedly required, whereas brand companies, at least in principle, have that regulation, that pathway available to them. So now it's all about whether the CBE reg was available to you to do what state law supposedly required. And that's a much better analysis for arguing for preemption if you're a brand company than Wyeth, because it's very straightforward, and it's a legal question. The CBE regulation, 21 CFR 314.70 C6, lays out various standards, various circumstances under which you can make a unilateral label change without FDA approval. And you have to meet those standards. It doesn't say that a brand company can change its label unilaterally whenever, however it wants. You have to meet the standards the reg sets out. And the first case that really, I think, reconciles mensing with Wyeth in the brand context and lays out the analysis in this favorable way is the First Circuit's decision from earlier this year in Lexapro. And that case focused on one of the criteria in the CBE reg. There is another one that I want to mention as well, but the issue there was the plaintiffs really, there's an excerpt from the opinion of a colloquy from the oral argument where the judges really got the plaintiff's lawyer to just openly agree to this, that the plaintiff's claim was that FDA had not correctly evaluated the information before it. There was not even a pretense that the label change the plaintiffs said should have been made was based on new information becoming available after FDA had made its label decision. It really was just second-guessing FDA's label decision. Well, obviously, FDA doesn't want companies to be able to do that. FDA doesn't want to devote the significant attention and expertise that it devotes to deciding exactly what your label should say, only to have you the next day change your label based not on anything new, but based on the same stuff that was before FDA. That obviously is not a tenable way for the system to work. And that's essentially what the plaintiffs in Lexapro were arguing that Forest Lab should have done. And so the First Circuit, in a very strong, very clear opinion by a unanimous panel, authored by an Obama appointee, that I think it's going to be hard for other courts to say is, an opinion that is too extreme in favor of preemption or fails to apply Wyeth faithfully. It's going to be hard for courts to say that. The court pointed out that the CBE regulation requires that a label change be based on new evidence and new information. And in that case, the plaintiffs were, in retrospect, pretty careless about not even making a show of saying they were relying on new information, and so that made it easy for the court. In other cases after Lexapro, presumably plaintiffs' lawyers will be a little more careful about that and will at least try to make it seem like they're relying on new information, but the argument will be available to defendants that they're not really. The second important aspect of the CBE regulation, not at issue in Lexapro, but that I want to mention briefly, is that in order to add or strengthen a warning, it has to be based not just on new information, but it has to be based on a significant quality of evidence. Not just new, but the quality of the evidence has to meet a standard. That standard is reasonable evidence of a causal association. Not proof of a causal association, but also not just anecdotal information that doesn't rise to the level of being reasonable evidence. This standard is the same standard that applies in the first instance when FDA decides what your label should say. And FDA quite reasonably said, you can't change your label based on a lower standard of a lower quality of information than what determines what your label how your label reads in the first instance. And so I think there will be cases where plaintiffs don't have a very good basis to say that you should have made a label change under state law. They'll be relying on more anecdotal type of information, less systematic scientific review, where maybe there isn't a lot out there for them to really go on, and their case for why you should have made a label change may very well not rise to the level of reasonable evidence of a causal association. That standard is obviously amorphous, and applying it is going to be challenging, and there'll be judgment calls in certain circumstances. But I think there will be cases where it's clear that the evidence the plaintiffs are relying on does not rise to that level, and therefore it would not have been proper under federal law for the company to use the CBE pathway to make that unilateral label change. And I think now that that's the legal analysis, I think it will be very interesting to see if companies try to reinvigorate a preemption defense. In the immediate aftermath of Wyeth, the opinion was so negative, hopes had been so high, and then were dashed that I think, absent some unusual circumstances, I think some companies really just thought, okay, we lost preemption, we gave it a shot, we lost, and now let's move on to other strategies. And I think that was premature, and I think Lexapro shows that it really is still open in a lot of factual circumstances, a lot of cases for companies to argue for preemption. The other pathway to argue for preemption is what Jay alluded to, this clear evidence exception that was laid out, or at least hinted at in Wyeth itself. And the case that there have been a few cases since Wyeth, which was 6 years ago, litigating this exception. And companies have won a few, but companies have lost more than they've won. And on the whole, courts have applied this exception very narrowly and have demanded something close to definitive proof that FDA did or would have rejected the exact label change that the plaintiffs said state law required. And in the nature of things, that standard is not going to be met very often, if ever. And so companies have not won too many cases. The case that illustrates this that I want to focus on is Reckitt, decided very recently by the Massachusetts High Court. At first, Reckitt seems like a great case for preemption because it involves children's Motrin. FDA decided a citizen's petition that asked for, in substance, the same warning to be added to the label that the plaintiffs say state law required. And FDA denied that citizen petition and said, no, you're not going to add that warning to the label because we don't think it's appropriate. And so you'd think, okay, perfect case for preemption. But the problem is that the plaintiffs, knowing that background, knowing that FDA had rejected their the citizen petition, decided that the warning that they were going to say state law required was slightly different from the one that FDA had rejected. In substance, not very different, maybe not different at all, but in terms of the wording, slightly different. And so that created an opening for the court, if it was so inclined, and it was, to say there's not clear enough evidence that FDA would have rejected that warning. We know FDA did reject this other warning. It's pretty similar, but we don't know for sure that FDA would have rejected that slight variation. And, you know, in fairness, we don't know for sure that FDA would have rejected that because that didn't happen. That's counterfactual. But we do know that FDA rejected something very similar and really in substance going to the same point. And if the clear evidence exception is going to be that kind of a magic word standard where you have to actually match up verbatim the language that FDA rejected with what state law supposedly required, then it's illusory because the plaintiffs know what FDA rejected and they're not going to be careless enough to argue that state law required the exact verbatim thing that FDA rejected. So it's not a coincidence that the plaintiff's warning in the Reckitt case was slightly different. I mean, that's the way the plaintiffs litigate these cases. And so if you really have to have a verbatim match, you're never going to have a verbatim match, and this exception becomes illusory. Hopefully, eventually, the U.S. Supreme Court will revisit this issue and will say, no, we meant this. This is a real exception. This is not illusory. The other thing I just want to mention very briefly, it's not preemption exactly, but it's related enough to this subject that it may be worth 30 seconds. And that's what some courts have referred to, or some plaintiffs' lawyers have referred to as innovator liability, which is a broad label that doesn't mean a whole lot, but what it means is in cases where you can't sue, where the plaintiff took the generic, but you can't sue the generic because of mensing, you sue the brand, and you say that it's the brand's fault that the generic failed to warn. And most states, as a matter of state law, rejected these claims and said that as a matter of state negligence law or misrepresentation law or what have you, a company doesn't owe a duty to consumers of some other company's product. Seems very logical, and like I said, most states had adopted that view. One notable exception was California. No one will be surprised to hear in a Court of Appeal decision called Conti some years ago. And that's where things stood. And then mensing was decided. And mensing made the issue a little bit more complicated because mensing made it clear that the generic, in fact, could not change its label unilaterally through the CBE regulation. And since mensing, the results have been a little more mixed. The Alabama Supreme Court, most notably last year, in a case called Weeks, went the other way and said that under Alabama law, that the brand company did owe a duty. It was a misrepresentation claim. It was not a negligence claim, and so the opinion is somewhat limited in that sense, but nonetheless it did hold that the brand company could be sued by someone who took only the generic. The Alabama legislature made short work of that and overruled that legislatively not long after. So that decision has no legs in Alabama. Whether other courts will follow it remains to be seen, but that's where that issue stands for now. If you're a brand company and you thought 6 years ago that you might have a shot at getting a broad win from the Supreme Court in Wyeth on preemption, You lost that. You see the generics then get a win 2 years later in mensing. You still can almost never win preemption in the lower courts. And then you start getting sued by people who took the generic, and you think, there's really something wrong here. All these things can't be right. We need to either get a stronger preemption defense for us, or we need to not be able to be sued by the people who took some other company's product, not our own. And so it's been a challenging legal landscape for brand companies, but I do think Lexapro is a signal that maybe that's changing, and that there is hope, and brand companies should remember that preemption is available, should at least consider in each case whether preemption is a viable defense, and should not just still be having a hangover from Wyeth and think that preemption is dead and gone. It's not dead and gone. Thanks very much.
Thank you, Jeff. A couple of follow-up questions. You mentioned the Records case, and the alternative ground that the Massachusetts Supreme Judicial Court relied on was this notion that, well, the citizen's petition request had not been made by the company. It had been made by a group of doctors and expert witnesses, but not the company, and that might be a ground for denying the preemption defense, because perhaps the FDA would have reacted differently had the request to change the label come from the company itself. You've obviously spent a lot of time advising the agency on these issues and representing the agency. What do you make of the court's conclusion there?
So I think that notion doesn't really withstand scrutiny, but in defense of the Massachusetts court, they pulled that out of Wyeth from the majority opinion by Justice Stevens in Wyeth, where rather than frame the preemption issue as a legal one, could the brand company have used the CBE regulation consistent with the text of the CBE regulation to lawfully under federal law make the change? Justice Stevens' opinion framed the issue, at least in one part of the opinion, as if the brand company had done that, would FDA have gone after the company and brought an enforcement action and said, basically no, because we can't find any evidence that FDA has pursued enforcement actions against companies in similar circumstances. And so that's what the Massachusetts court was getting at. I don't think that makes any sense. I think preemption is a legal inquiry, and I think Lexapro reinforces this, that if the standard is, and mensing reinforces this, if the standard for impossibility or obstacle preemption is, could you properly under federal law do what state law supposedly required you to do? It can't be enough that you could do it improperly under federal law but get away with it in the sense that FDA wouldn't bring an enforcement action against you. You have to actually be able to properly do it under federal law. And so I think that aspect of the Records opinion is really does not withstand scrutiny.
Thank you. The one final question I have, Jeff. I remember when we were getting ready to argue mensing, one of the amicus briefs that was submitted by a law professor suggested that this whole regime of impossibility didn't make any sense because of drug companies' First Amendment rights. And obviously they have First Amendment rights to say whatever they want to say. Certainly they should be able to strengthen warnings. And we have seen in the last year the Amarin case, and now there's a new case, I think, Pacira has brought an action against the FDA where the FDA has basically been shut down in preventing promotional speech by drug companies. Do you think there's any danger that this more robust First Amendment protection could actually undercut preemption with drug companies?
It's a really good question. So I would be the last person to throw any cold water on the First Amendment efforts that the industry has gotten some traction with lately. I was privileged to represent Allergan in the First Amendment declaratory judgment action some years ago, and I'm very happy to see what the court in Amarin has done and what the Second Circuit did in Coronia, and I'm hopeful that the trend will continue in that positive direction. I think as long as those decisions are case-specific and fact-bound, the way certainly Amarin was, the CBE regulation isn't struck. It remains on the books. It remains valid. And certainly that those cases don't really even challenge the CBE regulation in any direct way. And I think that if you're in the current landscape, even if you believe, as I do, that the First Amendment does protect truthful commercial speech in this context and that FDA's regime has not caught up to that legal reality, I think the preemption analysis should turn on what the law currently is. And the positive law, as set forth in the CBE regulation, is you can't change your label to add or strengthen a warning or a contraindication unless A, it's based on new evidence, and B, it rises to the level of reasonable evidence of a causal association. If that reg gets struck down, and or the FDA eventually gets around to updating its legal regime to take account of modern First Amendment jurisprudence, then we might have to take a step back and reevaluate what effect that might all have on preemption. But I think that is unfortunately probably not a task for 2015, but for farther into the future.
Great. Thank you very much.
Thanks.
Willie?
Thank you, Jay. This is a daunting task for me in particular because Jay is sitting right over there having litigated almost all of the cases I'm going to talk about. So if at any point I am thrust away from the podium, you'll know that I said something wrong. But it's a privilege to be here, and thank you all. Let me, before I kind of get into the generic bit, let me add just a word to build on Jeff's answer to Jay's question about the First Amendment. And the Supreme Court said about 15 years ago in one of the motor vehicle cases, Geyer, that ordinarily in preemption cases, we presume that people are going to comply with the law. And a possible answer to that is, well, an unconstitutional regulation is no law at all, see Marbury versus Madison, right? But as Jeff said, this regulation remains on the books, and it would be certainly a novel extension of sort of non-preemption doctrine to say that because you could have brought a First Amendment action and you could have gotten an injunction, you could do it. You could have set the warning that we now want you to do. If the regulation is struck down, then warnings henceforth will be a different matter. But let me take a step back and reset to talk about generics in particular, and a little bit about Mensing and Bartlett, which I know most of our listeners already know about, and a little bit about the doctrinal strands of preemption that Jeff alluded to just briefly. So impossibility preemption is what the generics have successfully prevailed upon to date, and that's what Mensing rests on. You can't comply with the federal law and the proposed state law duty at the same time. Two virtues of impossibility preemption are, number one, it doesn't really matter what the agency thinks. In the other strand of preemption, purposes and objectives preemption or obstacle preemption, whichever name you give it, the court has historically given some weight to what the agency thinks and whether it says its purposes are being frustrated. Obstacle preemption is much neater. The court in Mensing took very seriously with the agency's views of what is illegal, but having concluded that it would be unlawful to change the label unilaterally, it didn't matter whether the agency thought that preemption was a good idea or a bad idea. Where generic preemption is now going is into the other strand. We're now dealing with arguments that rest on the other strand of preemption because plaintiffs are coming up with theories that don't conflict directly with the duty of sameness, the duty to have a label that is the same as the brands, at least in the plaintiff's conception of what labeling is and what sameness is and what a duty is and what state law is. I'm going to talk about each of those four things kind of in turn. So one theory, which Jay alluded to in his introduction, is the failure to update. You had a duty to make your label, you the generic had a duty to make your label the same as the brand's label. You didn't, perhaps for 30 days, perhaps for a longer period of time, and there are cases ticking along in the lower courts in which the delay is a bit longer than 30 days, sometimes considerably longer. And the question is, may that be litigated under a state law theory, and is it still preempted by Mensing? And the plaintiffs have, on the one hand, sworn up and down that they are relying only on a state law duty to warn. However, they point out, they cannot resist pointing out, that the state laws in question borrow the federal principle of what an adequate warning is. And they say, well, since if you give the federal warning, it's presumptively sufficient. If you don't give the warning that the brand is giving in its labeling, that is enough all by itself to establish that your warning is deficient. And the response that the generic companies have been litigating, which the Supreme Court has thus far declined to take up despite a really excellent petition that Jay did, was, how to put this, really, is it a question of state or federal law? Can you call it a state law duty when it so conveniently matches the duty that comes out of the federal regulations, and when the plaintiffs in their briefing enumerate each of the obligations under federal law to have the labeling be the same and the penalties that may follow, for example, the FDA's power to revoke an ANDA, an abbreviated new drug application, if the labeling is not the same. This implicates the Supreme Court's decision from about 15, 16 years ago called Buckman versus Plaintiffs' Legal Committee. The Food, Drug, and Cosmetics Act has a provision, Section 337 of Title 21, that says that private individuals may not enforce the FDCA. Actions to enforce the FDCA must be brought in the name of the United States and the United States only. And the question in Buckman was whether a state law tort, cleverly entitled fraud on the FDA, was enforcing the FDCA or was in fact an exercise in state law creation of tort liability. And the Supreme Court held that state tort was preempted precisely because the FDA had its own tools for enforcing the FDCA, and Congress had manifested its intent that the FDA and the United States, the federal government, be the sole enforcers of the FDCA. If the FDA is concerned that it is being lied to, the FDA can take action. But burdening the FDA with the consequences of this state law tort, lots and lots of letters from lots and lots of drug and device companies concerned about liability under state law, would be bad for the agency's mission. And the agency in that case filed a brief supporting preemption, purposes and objectives preemption, as I alluded to in the beginning. So the generic companies in these failure to update cases have been pointing to the duty to update that comes from federal law and federal regulations and saying that this is another Buckman case. This is interfering with the FDA's exclusive authority. And to take just one of the examples that the plaintiffs rely on, if the agency has the power to revoke the ANDA based on a failure to update labeling, it also has the power not to revoke the ANDA. Exactly the kind of enforcement discretion that has historically been vested in the agency and not in private plaintiffs. And the plaintiffs have responded, no, this is not Buckman because we're not enforcing that federal duty at all. We're just enforcing the state law duty to warn, not a duty of sameness. However, this is the second part of the argument, the warning that they are litigating is precisely the one warning that they say fits through the tiny brand-shaped hole in the wall of preemption. Any other warning would be preempted. If ordinarily in a warning case, the focus is on the deficiencies of the warning given, but here it has to be on one particular available warning that the brand is given, because if you deviate from that by even a tiny bit, well then their theory holds that preemption kicks in. Thus far, the Sixth Circuit has held that a failure to update claim can go forward, and so have a number of lower state courts, including the California Court of Appeal in the case that Jay tried to take to the U.S. Supreme Court. The Fifth Circuit, in a regrettably laconic decision, has gone the other way and has at least made clear in subsequent decisions that it's not going to change its mind, but did not spell out its reasoning in glorious detail. And the case that Jay took to the Supreme Court caused the court to call for the government to file a brief. And the government in that case, despite having supported preemption in Bartlett, government came in and said there is no preemption here, and you, the Supreme Court, shouldn't take this case for a whole number of particular vehicle reasons, including appellate jurisdiction for non-final cases coming out of state courts, the government's brief is interesting because it says we have no interest in frustrating private enforcement of this duty to warn because it arises under state law. And they cite the Merrill Dow case from the 80s, which said that an ingredient, if violation of federal law is an ingredient in a state law cause of action, well then it's still a state law cause of action for purposes of the federal subject matter jurisdiction statutes. Didn't really deal with this same preemption issue. But they say that as long as the caption slapped on the cause of action is a state law cause of action, then you're not really enforcing the FDCA. I think that's in substantial tension with Buckman itself and with the tort at issue in Buckman, but we don't yet know what the Supreme Court will think of that. And so that continues to slosh around the lower courts. And in a case involving metoclopramide, there's a large complex of cases in New Jersey State Court, and that matter has now been taken up somewhat surprisingly by the Supreme Court of New Jersey in a case that the appellate division in New Jersey had declined to rule on. The Supreme Court has now agreed to rule on it. It's fully briefed. It's awaiting oral argument. And while the Supreme Court of New Jersey might not be everyone's preferred forum to litigate this issue and get the next decision, that may be the next shoe to drop. The other theory I want to talk about is failure to communicate, which is not something from a Paul Newman movie, but is instead a theory that the company, a generic company, which gives the prescribed warning, in other words, it updates its label to comply with the duty of sameness, match what the brand has done. The generic company should have sent a Dear Doctor, or as the government insists on calling it, a Dear Healthcare Provider, or DHCP letter, saying, we just wanted to emphasize to you particular aspects of the new labeling. Now, the government dropped a footnote in its brief in Jay's case, which I should give you the name of, Teva versus Superior Court. The government dropped a footnote in its brief in that case saying there would be no problem sending a letter saying the brand has changed its label, we have not, here's what the new brand labeling would be. This is something quite different, and the government doesn't speak on that and says in its footnote that it's not speaking to this, that this is something over and above anything that the brand has communicated to doctors and to its patients. And the problem with that the generic companies vigorously argued in a number of these cases is that it signals to doctors and to the marketplace and to patients that exactly what Congress decreed in the Hatch-Waxman Act, that generic medicine is identical in all relevant senses to brand name medicine, is not true. Because here you're getting a letter from one generic company saying, here's a fact you ought to know about our product that does not match anything being told to you by others on the market. So those are the theories that are currently sloshing around. But sort of the elephant in the room, and one of the vehicle problems that the government raised in Jay's Teva versus Superior Court case is a rulemaking that FDA has put out for comment. And the government told the Supreme Court that it expected to act on it by September 2015, which it is now, and the government has not yet finalized that rulemaking and indeed reopened it for an additional hearing, which I'll talk about in a moment. The proposal is to change the CBE regulations so that generic companies could, for the first time, unilaterally change their own labeling. And as Jeff, I think, put very neatly, that would remove the key difference between generic companies and brand companies in a way that would eliminate preemption for both. And that clearly is what the government's intention is, because Mensing and Bartlett are discussed right there in the rulemaking documents. The other point in the rulemaking of some significance is the addition of a 30-day deadline for updating labeling to match the brands. Now, this is interesting for a number of reasons. Number one, the agency previously had given guidance, many, many years ago, that gave a series of different timeframes for updating based on how momentous the change was, and then the agency got away from that guidance. So it would now be reinstating a time period. But this is significant because if the agency is saying you may have 30 days, even if this regulation is adopted just as the agency proposed it, saying that you may have 30 days raises the very important preemption question: may someone litigate if on the theory that taking 30 days was too long? There have been a number of preemption cases in which federal regulation was held to be a floor but not a ceiling. And so adopting this regulation would raise the question, does it frustrate the purposes and objectives of the agency in giving companies 30 days to update? This too was something carved out in a footnote in the government's most recent brief on this subject in the Teva case. The rulemaking is not yet final, and both the generic and brand name trade associations have come to the agency with a proposal for a different approach. And that approach would be expedited review of labeling changes by the agency itself for brand and generic companies alike for important matters, that the agency would itself be able to triage labeling changes and, in appropriate cases, to bring them through expeditiously for brand and generic companies. I think that the consequence for preemption would again be to put brand and generic companies on the same footing, but a different footing than the one the government's proposal suggests. So I don't want to go on too long, but I'll just sort of close with the Supreme Court forecast and a couple of words about that. Most of what I've talked about has been about purposes and objectives preemption, obstacle preemption. And one important thing about the Wyeth case and about other subsequent cases in the Supreme Court is that Justice Thomas has declared that he is done with obstacle preemption. He does not believe that it is a legitimate exercise of the court's power under the Supremacy Clause. Justice Thomas, of course, was the author of Mensing, and the fact that it rested on impossibility preemption was therefore extremely significant, particularly because if there's one thing that the Bartlett case shows, it is that the dissenters in Mensing still think that Mensing is very, very, very wrong. So a purposes and objectives theory in the Supreme Court likely is going to have to, A, move more toward the impossibility line, B, convince somebody that Mensing is a good thing, or C, potentially, I'll call them C1 and C2, but they really are the same thing, persuade the agency of, that it's done something that justifies a change, and C2, persuading Justice Breyer that the agency is right, as Justice Breyer is wont to think. So with that, I'll wrap up.
So, Willie, I just want to ask you one question, and just to clarify for folks here, the agency has now said that it intends to promulgate its final regulation in February. They put something out. I'm not convinced that they have the authority to issue that regulation because of the clear language of Hatch-Waxman. We'll obviously challenge the regulation when it's issued, and we'll see what happens. One thing I want to ask you about is, you talked a little bit about Buckman, and the interesting thing in these failure to update cases is, and in particular the metoclopramide case, the very label change that the plaintiffs are alleging that the generics did not update, the plaintiffs are also alleging in the same complaint that that warning would not have been sufficient because they want to hold the brands accountable for a failure of a subsequent label change. So it's really not the case that they are alleging a failure to meet a state duty, because there can't be a state duty to inadequately warn. And so it's pretty clear in these cases that the only thing they are really alleging is a failure to comply with the federal obligation to have issued an update in accordance with federal regulations. And so it does seem like it does run right into Buckman, and although Buckman has been construed, I think by everyone, as really just a fraud on the FDA case, if you go back and you read the original Buckman complaint in the lower court, it was a pure common law, state common law tort claims. So I just wonder whether you think that we may get some more vitality on the Buckman issue going forward.
I mean, Buckman itself is sort of hugely important in preemption circles, and as broad circles that they be.
Small group.
For reasons, going beyond this.
Right.
And the government institutionally is going to have to think about essentially whether it wants to strangle Buckman the next time that it actually has to take a position on this. And I think there are certainly good institutional reasons and a number of client agencies within the government who would, or at least should, pause for an extended period before taking that step. But the point that you bring up about the other allegations in the same litigation, sort of proving the flaw in the plaintiff's theory, is an interesting point about the aggregate litigation that has become a feature of these cases. That you have plaintiffs' lawyers representing an enormous number of people, and by trying to have their cake and eat it too, they may be exposing the flaws in their own theory. That raises some very interesting personal jurisdiction and class action cases, which I hope we'll have another briefing on one day.
Terrific. Thank you very much.
Thank you. I'm going to speak about medical devices as opposed to drugs. I tend to represent medical device manufacturers, and they, unlike pharmaceutical manufacturers, are fortunate in that they can rely not only on implied preemption, but also on express preemption. The FDCA has a provision, 21 U.S.C. section 360 KA, which states that no state may establish any requirement relating to the safety or effectiveness of a medical device, which is different from or in addition to any federal requirement applicable to the device. So this is a major tool in the quiver of the medical device manufacturers that the drug manufacturers simply don't have available to them. The Supreme Court has twice interpreted Section 360 KA in Lohr and in Regal, as most listeners presumably are aware, and two things come out of those cases: that 360 KA applies to medical devices that have received pre-market approval from the FDA, but not to devices that were simply cleared through the 510K process. And second, that to avoid express preemption under 360 KA, a plaintiff must bring a so-called parallel claim, i.e. a claim that is predicated on the violation of a state law duty that is, quote, identical, quote, coming from Lohr, to a federal requirement. In the 15 minutes or so available to me today, I think I'm going to focus on two issues in the medical device preemption sphere that I think are issues that may well reach the Supreme Court in the coming years. One was the subject of a cert petition was denied last year. It's already been alluded to. The other is the subject of a cert petition that was filed just last week, though I don't think that cert petition is meritorious or will be granted. I think, nonetheless, the issue will ultimately get to the court. And those two issues are whether state tort claims based on a manufacturer's alleged failure to submit adverse event reports to the FDA survive express and implied preemption. And the second question is the effect, if any, that allegations of off-label promotion have on application of Section 360 KA. So, turning to the first question, do state law failure to warn claims based on a manufacturer's alleged failure to submit adverse event reports to the FDA survive express and implied preemption? Over the past several years, plaintiffs have asserted failure to warn claims based on manufacturers' alleged violations of 21 U.S.C. Section 360I and 21 CFR Section 803.50, which require medical device manufacturers to submit an adverse event report to the FDA whenever they learn of information suggesting that an approved device caused a death or serious injury or malfunction in a way that could cause death or serious injury. The courts are deeply divided. The federal courts are deeply divided on the issue whether such claims survive both express and implied preemption. Two circuits, the Fifth Circuit and the Ninth Circuit, have held that such claims are neither expressly nor impliedly preempted. The Ninth Circuit saying so in Stengel, and the Fifth Circuit saying so in Hughes a couple of years earlier. Two other circuits, the Sixth Circuit and the Eighth Circuit, have squarely held to the contrary. that such claims are impliedly preempted, and various district courts around the country have held that such claims are not only impliedly preempted, but also expressly preempted. So the Eighth Circuit in Bryant held such claims to be impliedly preempted, as did the Sixth Circuit in the Marsh case. Interesting, the Marsh case is actually a drug case, not a device case, but there's a similar adverse event reporting requirement with respect to drugs, and the Sixth Circuit said no, any claim based on the failure to comply with that regulation is impliedly preempted. And then several district courts, as I say, around the country have gone further and said these claims are not only impliedly preempted, but also expressly preempted. The Middle District of Florida in the McClellan case, the District of Minnesota in Pinsino, and the Northern District of Oklahoma, for example, in Little Bear. There are others. I won't give you an exhaustive list, but the fact is there's a deep divide amongst the federal courts and a clear circuit split on the issue. Now, the rationale for holding these claims not to be preempted, so in other words, the position taken by the Ninth and the Fifth Circuits in Stengel and Hughes is, I think, as follows. It's a little hard to say because the logic is not terribly compelling nor spelled out with tremendous clarity in those cases, but I think the logic is as follows, that state law imposes a duty to warn, and that manufacturers may discharge their duty to warn by warning third parties. That the FDA, when it receives adverse event reports, routinely posts them to the MAUDE database, which is publicly available, and that physicians are warned through the FDA's posting of adverse event reports, and that therefore the failure to submit the adverse event report to the FDA constitutes a state law failure to warn. That at least seems to be the logic. As I already alluded to, I really don't think this stands up to scrutiny, and I think failure to warn claims based on a manufacturer's alleged failure to file adverse event reports with the FDA are both expressly and impliedly preempted, contrary to the Fifth and Ninth Circuits. Now, I'd say that they're expressly preempted because the federal duty to submit reports to the FDA is not identical to the state law duty to warn patients or their physicians. Two things I think are worth noting. Although the FDA may disclose adverse event reports, it is not required to do so under 21 CFR 803.9, which means that adverse event reports, unlike actual warnings, are not necessarily made public. And if something's not made public, clearly it's not a warning, and the FDA in its discretion is not required to publicize adverse event reports. And if state law required a manufacturer to itself publicly disseminate adverse event reports, that then would be a state law requirement different from or in addition to the federal requirements, which merely require submission to the FDA and would therefore clearly be preempted under Regal and 360 KA. Neither the Fifth Circuit nor the Ninth Circuit in Stengel confronted 21 CFR 803.9, which is the provision that vests discretion in the FDA as to whether or not such reports will be made public. And I believe that these claims are also impliedly preempted, as the Sixth and Eighth Circuits and various district courts have held, because any duty to submit a report to the FDA is a duty that exists solely by virtue of the FDCA. And that means that any claim predicated on a violation of that duty is barred by 337A and Buckman. I think I find that conclusion inescapable, though obviously two circuits have escaped that conclusion. Now, interestingly, as has been mentioned a couple of times already, the Ninth Circuit's decision in Stengel gave rise to a cert petition by Medtronic, the manufacturer involved, and that petition was ultimately denied, but not after the court called for the views of the Solicitor General. And the Solicitor General filed a very interesting brief, which I think will continue to percolate in this area for a while. I think plaintiffs and defendants are both trying to figure out what to do with it. Basically, the Solicitor General came in and said, everyone's got it wrong, everyone misunderstands Regal, everyone misunderstands 360 KA, should throw it all out and start again, is sort of the bottom line. Now, literally, the SG said every federal court of appeals since Regal has misapplied it. Every single one. So at least there's no circuit split in their view. Now, the SG disagreed, in Stengel with the Ninth Circuit decision, the SG disagreed with the Ninth Circuit's analysis and by implication with the Fifth Circuit's analysis in Hughes, and suggested that failure to warn claims based on a failure to submit adverse event reports to the FDA may well be preempted, either expressly or impliedly, as I've suggested. So in a way, the SG's position is closer to mine on that narrow issue. But then the SG went on to say that all of that's irrelevant because, in the SG's view, plaintiffs can bring state law failure to warn claims based on post-approval information. According to the SG, state law may require a device manufacturer to change an FDA-approved label whenever, quote, new safety information exists. Relying on Wyeth, the SG asserted that failure to warn claims based on a manufacturer's failure to revise a label are not preempted by federal law because the CBE regulation permits device manufacturers to unilaterally change their labels without prior FDA approval. Now, there's one major flaw in that analysis, which is that Wyeth was a drug case, not a device case, and therefore was not subject to Section 360 KA. And while the CBE regulation may well permit manufacturers to unilaterally change their labels provisionally subject to ultimate FDA approval, it is precisely that. It's permission. They may do so, but federal law does not require them to do so. So if state law requires a manufacturer to change a label when federal law merely permits it, that is clearly the imposition of a state law requirement that is different from or in addition to the federal requirements, and therefore, as the Seventh Circuit had earlier held in the McMullen case, clearly preempted under Section 360 KA. And there's indeed a Supreme Court case, National Meat Association versus Harris, interpreting a similarly worded express preemption provision in which the court said, in effect, state laws may not, when they're subject to express preemption provisions such as the one you find in 360 KA, state law may not convert a federal may into a state law must. So I think these claims clearly fail under that test, too. The second issue that I think may well reach the Supreme Court at some point, though I do not think this term, because the cert petition that was filed Friday, I think, does not get the plaintiffs or the petitioners where they want to be, is the question of what effect, if any, do allegations of off-label promotion have on application of Section 360 KA, the express preemption provision applicable to devices. Over the past several years, there have been hundreds of suits filed across the United States asserting state law claims for injuries allegedly caused by off-label use of a medical device, which off-label use was allegedly induced by the manufacturer's purported promotion of such uses. Now, plaintiffs have argued, and a few courts have agreed, that Section 360 KA does not apply to claims based on off-label promotion. The theories are varied and internally inconsistent. You really have the sense that courts are desperately grasping for a result rather than following logical analysis. But in any event, the theories are varied and inconsistent, but generally depend on two propositions. First, the proposition that federal law, specifically the FDCA's misbranding provision, prohibits off-label promotion. And second, the proposition that pre-market approval is use-specific. Now, the vast majority of courts, including the two federal courts of appeals to have considered the issue, namely the 10th Circuit in Kaplinger and the 2nd Circuit most recently in Otis Wisher, have rejected those arguments and have held that claims predicated on alleged off-label promotion to be preempted either entirely or in large measure. Now, remember, to state a parallel claim that avoids express preemption in 360 KA, you have to base it on a predicate federal violation, which is then, or the violation of a federal requirement, which is identical to a state law requirement. Now, if federal law does not prohibit off-label promotion as such, then any claim based on off-label promotion as such necessarily fails and is preempted under Section 360 KA. And it's been alluded to already in the panel, several courts have of late, most notably the 2nd Circuit in Coronia, held that the FDCA does not expressly prohibit and cannot be construed to prohibit off-label promotion. And indeed, the FDA, or the United States government, I should say, has twice filed briefs in the past several years, in the Coronia case and then in the Millennium Pharmaceutical case, stating that off-label promotion does not constitute misbranding and is not itself a prohibited act. And if that is in fact the case, that off-label promotion is not prohibited by the FDCA, any claims based on off-label promotion should fail at the very outset. But it is, I will acknowledge, a disputed proposition whether or not the FDCA does or does not prohibit off-label promotion. There's certainly cases predating the Supreme Court's decision in IMS versus Sorrell, which is what the Second Circuit relied on in Coronia, holding that off-label promotion is in fact illegal under the FDCA, pointing to various loose statements by the FDCA in certain guidance documents principally. But various courts, including the 10th Circuit, for example, in Kaplinger, held that even if federal law does prohibit off-label promotion, state law tort claims based on off-label promotion nonetheless fail and are expressly preempted under Section 360KA because there is no state law prohibition on off-label promotion. And moreover, these courts hold, or some would hold, have held, some lower courts have held, and I would certainly argue that claims based on off-label promotion are not only expressly preempted for that reason, but also impliedly preempted because any prohibition on off-label promotion, if it exists at all, is a prohibition created solely by the FDCA, and as Buckman clearly teaches, any claim that rests on the existence of the federal enactments is a claim that is prohibited under the Section 337A, which vests all rights to enforce, all power to enforce the FDCA in the federal government and divests private parties of any such rights. Now, as I say, so far, no circuit split. Both circuits have considered the issue, have ruled in favor of the defendant, and found such claims to be preempted. Now, the second suggestion, which I alluded to, is a proposition that the plaintiffs rely on, a few courts have accepted, is the notion that PMA, as a pre-market approval, is use-specific, and that Section 360KA does not extend to off-label uses. But that proposition is plainly contrary to the text of the FDCA, which at 21 U.S.C. Section 396 explicitly prohibits the FDA from limiting how approved devices are used, and moreover, expressly in 360KA, expressly preempts state law requirements with respect to devices without any reference to how such devices are being used. And indeed, the notion that 360KA does not apply to off-label uses is directly contrary to Regal itself, Regal being the seminal case interpreting 360KA, which held that the plaintiff's claims were in fact preempted, notwithstanding the fact that the device in that case was used in an off-label manner. The assertion that 360KA does not apply to claims arising from off-label promotion as opposed to just off-label use, I think would lead to an illogical result that simply cannot be reconciled with Section 360KA. On plaintiff's theory, claims arising from one doctor's unilateral decision to use a device in an off-label manner would be subject to Section 360KA because on that hypothetical there was no off-label promotion. But claims arising from another doctor's decision to make the same use of the same device would not be subject to Section 360KA if that doctor's decision to make off-label use was the result of off-label promotion by the manufacturer. But that result simply cannot be correct because, as the Supreme Court stated in Regal, application of Section 360KA depends on whether the federal government has established requirements applicable to the device. And for any given device, at any given time, either there are federal requirements applicable to it or there are not. It simply can't be the case that there simultaneously are and aren't. And so I think plaintiff's position collapses under its own weight. As I say, last week, the plaintiff in Kaplinger filed a cert petition, which obviously we will vigorously work against. And looking at the cert petition, I don't think it's going to be granted, but who knows?
Thank you very much, Andrew. I think we have probably time for one question, and so I'll open it up if anyone here has a question. I thought the presentations were all fascinating. If you have a question, I'm happy to echo it here, or if you have a microphone, you can use the microphone.
Richard Sam, I just have a general question about the seems to me that there's really no evidence that Congress really does have this intent not to preempt state law. That all the time they do it. But I haven't seen any evidence that the Supreme Court is turning away from acceptance of it, although in some cases it doesn't mention the presumption at all. I'm wondering what you see as the future of trying to eliminate the presumption, and in the end, do you think it makes any difference, or is it only cited by judges who have already come up with a predetermined decision that they want to preempt?
Well, Willie, do you want to take a stab at that?
You know, 4 justices, you know, were not 5, were willing to say that it should play no role in the analysis at all. But I do think in the lower courts, it appears in opinions quite a lot. There are a few lower courts that I think have tried to bring it more under control and have said something along the lines of, yes, Congress must make its intent to preempt manifest. When there's an express preemption clause, that does a pretty good job of manifesting it. Now, there are some Supreme Court decisions, though, that say you're supposed to read express preemption clauses, you know, essentially as narrowly as possible, because what if Congress, you know, didn't mean to preempt everything that you might read it to extend? But I think that to the extent that lower courts have started to nibble away at, or just, let's just say back away from the presumption, it's been in the express cases more than the implied cases.
Just I'll add one quick thing, which is I don't think it makes any sense to apply a presumption against preemption to express preemption provisions, because there you have a statute like any other statute and you should interpret it like a statute. I also don't think it makes any sense to apply a presumption against preemption in the context of impossibility preemption, because the Constitution contains its own presumption in favor of preemption called the Supremacy Clause, where there's an actual conflict. And where you're talking about impossibility, it's clear that there's a real conflict. And so presuming that Congress intended that conflict, you know, to be okay, that doesn't make any sense. That's contrary to the text of the Constitution. If there's a role for any kind of presumption against preemption, it might be in the context of what degree of obstacle is enough of an obstacle for obstacle preemption. Should Congress be presumed to tolerate, you know, maybe a little bit of tension between state law claims and a federal regulatory regime in an area of traditional state competence, or should there be no presumption? You know, in that's not the way the Supreme Court has articulated it. But if courts were a little bit more, I don't know, careful or intellectually clear about the role of a presumption here in different contexts, maybe it would be that.
Very good. Thank you all very much, and thank you to the panelists.
But